This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're speaking about fraud in the presentation of a claim and the investigation and how to investigate a fraudulent claim. To properly investigate a fraudulent insurance claim, it is necessary that the investigator and the insurer for whom he or she works understands the law relating to insurance fraud and the rights of the insurer and its investigators have to obtain the necessary evidence to prove a fraud has been attempted. Insurance fraud in the presentation of a claim by definition voids the entire policy. In 1884, the U.S. Supreme Court considered the issue and decided that a fraud in the presentation of a claim, even if it was not intended to deceive the insurer and would have had little effect on the indemnity paid, still caused the policy to be void and the claim to be effectively denied. In Claflin Others versus Commonwealth Insurance Company, the U.S. Supreme Court in 1884 found that after a loss, a person named Murphy assigned his claims against the several companies under policies to the plaintiffs. Claflin held that the materiality of a statement is not defined and determined by the effect it has on the outcome of the investigation. Rather, a question and answer are material when they relate to the insured's duty to give to the insurer all the information he has as well as other sources of information so that the insurer can make a determination of its obligations. The defendant insurers had issued insurance policies on certain goods. Plaintiffs were assigned the goods and brought suits under the policies against defendants as assignees of the original insured. After determining that the lower court had jurisdiction over the matter, the court affirmed judgment for the defendant insurers because the record showed that the assignor had made false statements and therefore plaintiff as assignees could not prevail. In any view, there was a fraud attempted upon the insurers, and it is not lessened because the motive that induced it was something in addition to the possible injury to them that it might work. The supposition proceeds upon the very ground of the false statement of a material matter knowingly and willfully made, with the intent to deceive the defendants in error. And it is no palliation of the fraud that Murphy did not mean thereby to prejudice the insurers, but merely to promote his own personal interest in a matter not involved in the contract with them. By the contract, the companies were entitled to know from him all the circumstances of his purchase of the property insured, including the amount of the price paid and in what manner payment was made, and false statements willfully made under oath intended to conceal the truth of these points constituted an attempted fraud by false swearing, which was a breach of the conditions of the policy and therefore constituted a bar to the recovery of the insurance promised. Now, investigators also must be aware about intentional misrepresentations, different from those of Mr. Murphy, whose misrepresentations were unintentional. Almost every insurance policy issued in the United States has a clause equal to or similar to that in the New York Standard Fire Insurance Policy that, like the standard fire policy in most states, provides that in relevant part as follows, quote, "This entire policy shall be void if, whether before or after a loss, the insured has willfully concealed or misrepresented any material fact or circumstance concerning the insurance or the subject thereof, or the interest of the insured therein, or in case of any fraud or false swearing by the insured relating thereto. The fraud investigators must understand that an insured who lies about material facts is grounds to refuse coverage for fraud. For example, when an insured lied intentionally about a claim to prevent her criminally violent son from harming her physically, sued the insurer who denied the claim when it learned she had lied to him, she failed to recover any benefits because the concealment or fraud provision of her policy effectively barred her claim. In my opinion, anyone who is charged with investigating insurance fraud must be capable of gathering admissible evidence that shows an intentional misrepresentation or concealment of material facts. With that evidence, the right to the benefits of the insurance policy are forfeited. And that's what the investigators in the Claflin case did, and that's what the investigators involving the woman whose violent son committed damage to her property and threatened to kill her if she told anyone. Both were intentional lies. Both resulted in the voidance of coverage. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,950 blog postings. You can also subscribe to these videos. They're free on YouTube and rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.